Let's bring in Mark Joseph. He's the Director of Litigation over at the Democracy Fund. Mark, what do you think about today's decision? I'm a little surprised because I'm a cynic generally, but I'm happy to see it. Boy, am I ever.
Right. I mean, I was a little skeptical that
Yeah.
that we'd get a good result here for various reasons I won't get into, but I'm pleasantly surprised. I haven't read the entire decision. I'm just kind of sort of scanning it, but it
Mhm.
seems that they affirm most or all of the major findings and ruling of Justice Mosley. I mean, Justice Mosley is an esteemed judge. He does have experience with the security apparatus, so he's well aware of the thresholds of the legal tests here and the violence that was required to invoke the Emergencies Act. So he gave the government's case a comprehensive hearing, and to see that the Court of Appeal has agreed with him is heartening. Again, I haven't
Yeah.
reviewed the decision, but it looks like they accepted the findings and the rulings of Justice Mosley, which I thought were quite well written.
Yeah. I mean, I think it is paragraph 505. We're satisfied with the protesters' right to freedom of expression sufficiently accounted for their related right to associate with others who shared their views. Uh,
Mm.
I, I just, it's just very irritating that the federal government proceeded with this appeal,
Yeah.
except insofar as they wanted to use the Emergencies Act as easily again, I suppose. I guess you can do these sorts of things when you have unlimited amounts of money to go after citizens and violate their rights.
Well, and
Yeah,
they clearly came out with the announcement that they were going to appeal before they even read the decision.
Right.
And I remember, I think I'd asked Keith Wilson about that and he basically said the government had no other option but to say they were going to appeal. Otherwise, they're just rolling over and admitting that they were wrong. And I mean, when have we ever seen that happen? Right? Like they weren't going to do that. So, yeah, sorry.
Go ahead, Mark.
no, I mean, look, it was an inherently political decision to invoke the Emergencies Act. The problem for the government is that the courts are going to apply a legal analysis to that internal discussion that led to that decision, and Justice Mosley found that it wasn't reasonable. And I think, I mean, obviously, I was biased because that was our position, but it seemed like the threshold just wasn't met to us. That was our position. We took at POEC. But there was no national emergency. They might have been local emergencies, maybe, or um, local problems in specific areas with respect to trade and economics, but that didn't rise to the level of a national problem. And the issues didn't fit into the definitions of the four definitions of emergency under the Emergencies Act, which imported the definition of emergency from the CSIS Act. So that was the problem for the government. There just wasn't evidence, as found by Justice Mosley, of serious use or threat of violence, or serious violence, as they say. So I didn't think the government could overcome that, and it looks like the Court of Appeal agreed with Justice Mosley. So, but I think the government had to appeal because it was a political decision inherently to invoke the Emergencies Act. But apparently they did that improperly.
Yeah, I mean, to equate um like wide scale potential for national violence with parking violations and noise violations, um, you'd have to be out of your mind to invoke the Emergencies Act over that, but they did. They did. But
Right.
I'm very pleased to see that the lower court was reaffirmed here.
Yeah, I mean, we have it right here. So I'm just reviewing the
Yeah,
judgment,
please.
so my thoughts are going to be
Mhm.
scattered.
Yeah, please.
Yeah,
Uh,
go ahead.
a little bit, but it has in paragraph 234, we have already found that cabinet, on the evidence that was before it and on proper interpretation of the act, did not have reasonable grounds to believe that a threat to national security existed. So that is almost an insuperable problem for the government if they wanted to appeal the Supreme Court of Canada, because it's a judicial review, and they have to find that the decision was reasonable. And how can it be reasonable if on the evidence there was there can be no finding of a national threat to security? It just so they could appeal to the Supreme Court. The Supreme Court has to agree to hear it, but that's a serious, I think, an insuperable problem for the
I
government.
think, and I'm reviewing this the same way you are, and I'm not a lawyer. So you jump in if I'm being crazy. But paragraphs 231 and 232. As for the threat or use of acts of serious violence against persons, when properly understood as requiring bodily harm, the evidence is quite simply lacking. Aside from the economic disturbance, they say, the only instance of violence put forward by the AGC was the seizure of a cache of firearms and ammunition at Coots, as well as vague reports of harassment, intimidation, assault, and the fact that the police forces in Ottawa were overwhelmed. In our view, this is insufficient to satisfy the compelling and credible information requirement to justify the conclusion that there were reasonable grounds to believe that there was a threat or use of acts of serious violence. Declaring a public order emergency is a very serious matter, considering the extraordinary powers vested in the executive branch of the federal government once the act is invoked. And for that reason, the exacting requirements set out by Parliament must be strictly adhered to. As disturbing and disruptive the blockades and the convoy protests in Ottawa could be, not that they were, but could be, they fell well short of a threat to national security. This was borne out by CSIS's own threat assessment and the fact that although an alternative threat assessment was requested, the GIC invoked the act before it was completed is another critical factor. So they didn't even wait to for more information because they didn't care if more information came in. They were going to do what they were going to do anyway. But I think those two paragraphs are pretty damning.
They knew we were moving trucks out of residential areas. We knew they knew we struck a deal with the citizens of Ottawa. We knew that they were going to do this out of spite, and that's exactly what they did. When you have somebody like Brian Peckford, the last living signature of the charter, standing in Ottawa with us, supporting us, but yet media ignored that and they try and demonize that, it just goes to show you just how far down a rabbit hole these people will go to prove their side.
Yeah.
Yeah, I mean, looking back, and this is obviously with the benefit of hindsight, but protest was kind of a typical Canadian or characteristically Canadian protest, and then a characteristically bumbled overreaction to that protest, right? I mean, you had bouncy castles, improvised, hot tubs and field hockey games and families and balloons. I compare that type of protest to something you'd see by the farmers in France, or American BLM protesters, and then the state's response to those protests. It's like there was a disconnect here with the Canadian government's response. You don't send out the troops in that sort of situation. It didn't seem appropriate, and I guess the Court of Appeal looked at that and said, okay, well, the grounds the government had here, and it just didn't meet the test, which seems obvious now, but that's why we're all so shocked, because at the time we're like, well, I guess this makes sense for the Canadian government to bumble it and send the troops in to take over the field hockey, the street hockey game, I guess.
And the feeding of the homeless. Those monsters.
I know.
Paragraph 254 also lays out that basically that there's nothing happening that they couldn't have dealt with using ordinary police powers. At 254, sorry, 254. From carrying weapons to a public meeting, causing a disturbance, fighting, shouting, swearing, all of those things, if indeed they were happening, and they weren't really, it starts with that being said. I don't know if we're looking under the same thing anymore, but paragraph 254, they basically lay out that any of the existing potential problems that I don't think charges were even laid for. They could have been easily dealt with existing police powers and not, um, invoking a wartime law that you would use for Pearl Harbor style attacks.
Yeah.
So,
And again, don't forget that, um, we were talking with Mark about this last night. Like during the convoy, I mean, we left the red zone numerous times. And as soon as you got out of the red zone, I mean, it was business as usual in Ottawa. You wouldn't have even known that there was a bunch of trucks there. Like, and we're just talking like a few blocks away. You couldn't hear the noise. There wasn't, the streets weren't congested. So essentially, I mean, they were frustrated, I think, and we're talking about a government that really deals in optics, in my opinion.
yeah.
And I think the invocation of the Emergencies Act was just another way to try and say, look, look how bad these guys are. Look at how terrible these guys are. We have to invoke, martial law to have them removed from our streets. And as you said, none of us were charged under the EA. We were charged under the criminal code, proving what you just said. There was tools within law enforcement under the criminal code that dealt and in fact did deal with us, I guess.
Just one last thing while we still have Mark. He's a lawyer, I'm not. But I just want to read this paragraph because it looks like the court even seems to recognize that the location of the protest was legitimate based on the message you guys were trying to send. So it's
Oh wow.
paragraph 334. The symbolic location of protests at border crossings and on the streets in front of Parliament Hill also cannot be overlooked as it too conveyed meaning. This is because the dissemination of an idea is most effective when there are a large number of listeners, and that the economic and social structure of our society is such that the largest number of individuals or potential listeners is often to be found in places that are state property. State property, such as border crossings and Parliament Hill, are thus ideal locations for persons wishing to communicate ideas.
Wow.
Mm-hmm.
Well
Yeah,
said.
that looks like it comes under the section about whether
Yeah.
the protest constitutes expression,
Yes.
and I think courts in the past have said, I think Supreme Court has said, parking a car can constitute expression.
They
Right,
do
so it's
say
a
that.
so it's a pretty broad interpretation of expression. I think there's no question that this was expression, and the good and bad thing about our Constitution is that it has that test right in it that says, okay, you have all these rights, but they can be limited.
Yeah.
As long as it's justified in a free and democratic, blah blah blah. So that exceptions tends to overwhelm the rule. I haven't read through this judgment, but I think they did affirm that there were some charter infringements here on the rights of the protesters, which should be no surprise. I mean, that's what Justice Mosley said. The seizing of the bank accounts were clearly wrongly done. That was I think Section 8 infringement. And then the blanket prohibition on a protest, any type of protest in and around the area was too broad. And that was an infringement, I think, Section 2B. But again, I'll have to read the judgment.